Good morning, all. My name is Peter Helder Bernard. I'm an attorney from the firm of Bernard and Yan, and I've been practicing for the past 26 years, focusing primarily in the area of immigration law and criminal law. And I decided to do this video today in light of the recent case that is before the Supreme Court regarding birthright citizenship. What I propose to do this morning is to elucidate some of the issues at hand pertaining to birthright citizenship, primarily discussing how one acquires American citizenship and the issue of jurisdiction within the 14th Amendment. Now, as a matter of law, generally there are 5 ways to acquire U.S. citizenship. You acquire citizenship by birth, by naturalization, by acquisition, by derivation, and by adoption. I'm going to try to explain that quickly. By birth, by virtue of the doctrine of jus soli, meaning the right of the soil. I have to explain that there are 2 doctrines of law which basically govern citizenship by birth. It's the jus soli and jus sanguinis. The jus soli means the right of the soil, and jus sanguinis means the right of lineage. We have to say that here in America, and many countries for that matter, there's a mixed perspective of the 2. In other words, it's not just one doctrine. Here in the United States, of course, you're born American soil, you're automatically a U.S. citizen, but you may, as you will see when I explain further down the road, that you may also acquire citizenship by virtue of your lineage, from your acquired citizenship from your mom, from your dad, etc. So that would be a form of jus sanguinis, which in fact means which is, like I said, it's a mixture of the 2. Now, citizenship by birth, as we explained, so you're born in American soil, you're automatically a U.S. citizen. By naturalization, naturalization is mostly of a contractual issue. It's a contract between you, the person, and the state, where you accept you receive a series of privileges and rights, and you also have some obligations. So this is a contractual issue. It can be revoked, and also generally naturalization. If you the only way that you lose your citizenship, if you acquired it by naturalization, is if there was fraud within the legal instrument by which you acquired that citizenship, which is the N-400, the application itself, and or by treason. So these are the 2 ways in which one could actually have your citizenship revoked. Now, by acquisition, it gets a little more complicated there. Acquisition is by virtue of your parents, one of your parents being a U.S. citizen, he goes abroad and has a child. The child is born abroad, and by virtue of that person being a U.S. citizen, that child may have acquired citizenship by acquisition, meaning the child acquired citizenship at birth, but there are, of course, here again some conditions that which have to be met. For instance, if you are to acquire citizenship by acquisition nowadays, it requires for the parent to have lived here in the United States at least 5 years prior to the birth of the child, and at least 2 years after the person's 14th birthday. So it changes constantly. It used to be 10 years for the father, etc., but now it's really 5 years, and from any parent, and in 5 years, and with 2 years living here after your 14th birthday. That is acquisition. So that child would actually, there's a process for it. The child will file an N-600, and the child would be eligible to receive a birth certificate of nationality, and by so on become a U.S. citizen and you have your passport, etc. By derivation is a different process. When person acquires citizenship by derivation, it means that you have one of your parents who is in the process, who naturalizes to become a U.S. citizen, and you, at that particular moment, you're a child under 18 years old, and you already have legal status, meaning you already are a lawful permanent resident. And by operation of law, you automatically yourself you derive citizenship from the naturalizing parent. Now, there was in the past, prior to the Child Statute Protection Act, issues of custody. Now, which they required that you be within the custody of the naturalizing parent, etc., etc. These are no longer, they don't require that. It's no longer the same. So it's an easier process nowadays. But you have to, it's done by operation of law. In other words, what that means is that you don't have to do anything. By operation of law, you automatically derive from the naturalizing parent and you become a U.S. citizen. By adoption, it's a process as well where the adopting parent is a U.S. citizen, adopts the child overseas. It's a dual process. You have the adoption, and then you have the USCIS process by which the parent, after the adoption, and starts a process with the filing of N600, etc. Now, these are very tedious process right now, ever since the Hague Convention, which requires, there's a whole lot of formality. It's no longer a simple process because there were a lot of children which were being basically kidnapped from some countries, etc. So they have made this quite a tedious process. You need to have what they call now a service provider. So it's no longer that easy to do it. Actually, attorneys basically are almost out of the equation. It's the service provider does it all. So it's a more tedious process. But this is how a child who has been adopted would acquire citizenship through the adopting parent by filing N600. But as I said, it's a whole process. You have to there has to be a home study, etc., etc. There's a whole process. It's a costly process as well, but it's a doable process. Of course, I advise for you to contact an attorney who knows what he's doing to help you in that process if this is what you would like to do. Now, moving on to the issue at hand, which is the issue with the 14th Amendment. Now, the 14th Amendment reads that all persons born in the United States or naturalized and who are within the jurisdiction thereof of the United States are, U.S. citizens. Now, I'm just paraphrasing. Don't quote me on that because, I don't remember verbatim what it says. But now the key point, the key issue, the key phrase in this paragraph is within the jurisdiction thereof. What does that mean? And this is the big issue at hand before the Supreme Court. Well, it's not that complicated. What it means, in fact, is that any such person born in the United States or naturalized who is subject or amenable before U.S. courts, who can be detained by U.S. authorities, whether it be state or federal. Any such person who can be, in fact, sued in American courts and found liable before American courts, any such person who is born in the United States and who is subject to the authority of the United States is thereby a United States citizen by virtue of their birth or by virtue of their naturalization. So now the issue becomes here, we are saying, of course, you understand that the 14th Amendment was adopted in 1868, if I'm not mistaken. It's after what we call, what was known as a Dred Scott cases or case. We say cases because it's a case that went through different steps. But the Dred Scott case of 1857, where citizenship was refused and was not recognized for black people, for sons of slaves or for sons of former slaves, and etc. So in trying to rebut this and trying to fix to alleviate the badges of slavery, like we say, they came about with the 14th Amendment after the Civil War, and to make sure that citizenship was guaranteed for slaves and sons of former slaves. Now, freed slave, there were no slaves anymore. So now the question that one may have: who is within the jurisdiction of the United States? For instance, a child born of a diplomat, for instance, a diplomat who comes to the United States and has a child. Like, let's say you're an ambassador for India, and you come here to the United States, and you have a wife, and she's pregnant, she has a child. That child will have a U.S. Birth certificate. But like we will find out, having a U.S. birth certificate is not in itself a legal determination of citizenship. It is not. It is sometimes proof of citizenship, but it is not a final conclusion of citizenship. So, in other words, you would have, because any person born in a U.S. hospital will have a U.S. valid birth certificate, but you're not per se a United States citizen because you have a United States or U.S. Birth certificate. There is a process by which, for instance, if you apply for a passport, the State Department would look at, when they do the investigation prior to issuing the passport, find out that you were born, that your parents were diplomats, and you would not therefore have U.S. citizenship, although you'd be in possession of a birth certificate, because you're not within the jurisdiction of the United States. In other words, you have immunity. You derive immunity because when you come as a diplomat, you come on an A1, A2 visa, which and you have therefore you have full immunity. Now, in some cases, the issue of full immunity is extremely important because in some cases you may have limited immunity. In the cases of limited immunity, for instance, if you're consul general or you're a consul, you are here for consular processing, you're a consular officer, you may have limited immunity. In the case where you have limited immunity, well, you may, if you have a child here, the child may in fact be a U.S. citizen. So these are very tedious questions. Who is and who is not within the jurisdiction of the United States? So, for instance, there also is very important. If you are a diplomat and you marry a United States citizen, that your spouse, who is within the jurisdiction of the United States, because the person is already a United States citizen, or a lawful permanent resident for that matter, within the jurisdiction of the United States, and you are married to that person has a child, well, the spouse would be the anchoring spouse, the child would derive citizenship from that anchoring spouse. We call it the anchoring spouse because she is the person, or he is the person through which the child would in fact derive citizenship. So if a diplomat has a child with a United States citizen or a lawful permanent resident or any person within the United States, that person can in fact, the child may derive, the probably derivation is not the right word, but the child that person would be the anchoring parent, and the child would in fact be entitled to U.S. citizenship because of that issue. So it's very important to understand these legal distinctions. Now, before the court, the issue at hand is who is and who is not within the jurisdiction thereof of the United States. As I explained, to be within the jurisdiction of the United States, you have to be honorable before American courts, and you must be also subject to the authority of state and federal officials. Okay, I hope that this helped. Again, if you have any questions and you have any legal issues, immigration, criminal law, and you need an attorney, of course, the attorney is always on your side. You can call us at 718 for our New York office, 718-413-2412, 718-413-2412, or you can call us here in our Florida office at 305-650-9884. I hope this helped. Have a great day and happy Easter to all. Thank you.